and welcome to Rightly Decided, the most originalist takes of the litigators of the Texas Public Policy Foundation. I am Laura Beth Latimer, and I'm here with our Director of Litigation, Chance Weldon, and attorneys Clayton Calvin and Nathan Seltzer.
Hey, thanks for having us.
And we are here to bring you Supreme Court cases. We're going to be covering Supreme Court cases as they drop this session, and we just got one this morning. Learning Resources v. Trump. It's the Trump tariff case. So let's get into it. What is this case about? What are we here to talk about?
Well, we're here to talk about tariffs, and they are apparently, as issued under IEEPA, they are unconstitutional. And I say apparently because that is literally the only, I say unconstitutional, I mean against statute. Mm-hmm. And I say apparently because that is really the only thing that the court agrees on is that they violate the statute IEEPA. What they don't agree on is why. So we have courts from the liberal wing and the conservative wing agreeing that the president does not have authority under IEEPA to issue the tariffs, but they don't agree why at all. And the only thing that they agree on is that the lower court's opinion should be upheld.
So the lower court's opinion should be upheld. What does that mean in layman's terms?
Well, that means that we're going to go back to the Court of International Trade, and they're going to decide what happens from here. Whether or not there's going to be refunds, we don't know. But we do know that the court will not allow the tariffs to be imposed under this statute going forward. And that's all we know.
But really the bottom line is just this is a violation of IEEPA, not the Constitution, but this is a violation of IEEPA, and therefore these tariffs are illegal and can't continue to proceed.
Under this statute, right?
Under this statute. Mm-hmm. So let's start with the majority opinion. What did the court do? What was it? What was the communication of the court as a whole?
So I think we'll just start with Justice Roberts. And Justice Roberts only wrote ultimately for 3 justices. It agreed in full with his reasoning, but it was considered the opinion of the court, though the reasoning will not be binding, which we can nerd out on that later if you guys want. But it's a puzzle in and of itself.
Yes, quite.
But the argument was basically whether or not this statute, which granted the president limited authority to regulate trade, included the authority to impose global tariffs, varying tariffs of indefinite duration against multiple countries across the world. And that was the question that was before the court.
Why is it important that these tariffs come out of this specific statute as opposed to other statutes that allow the president to levy tariffs?
Well, that was ultimately the choice of the administration. And I think what's important to remember, going back to Schoolhouse Rock, is that if the president wants to do something, he has to have authority to do it. Anyone in the federal government, if they want to do something, they have to point to something that gives them the authority to do it. And ordinarily, the executive branch doesn't have authority to, say, raise taxes or levy tariffs or do any of that stuff. So they have to point to some sort of congressional authorization. And here, what he pointed to was IEEPA, this statute which gave him the authority to regulate certain imports and exports.
And we think, it's likely that the reason that was such an appealing choice for the administration, that choice of statute, specifically was because of how broad the power is that it grants. There's no duration. You can invoke an emergency, but I don't think there's a duration period. Yep. And so it just that's what makes it appealing for an executive.
It kind of seems to me like the easiest route for the court to go would have been to turn to this kind of emergencies concept and say, no, it's not an emergency. They're just trading more with us. Why did the court not go that direction?
Well, I don't think you could count to 5 on this court to even say that emergencies are justiciable. The courts can even figure out what an emergency is. The statute itself says that the president has the authority to declare one, right, but it doesn't define what an emergency actually is. Right. So there's not a lot of judicial work to be done there. So instead it focused on whether or not, assuming there is an emergency, this, tariffs are within the enumerated list of things under IEEPA that the president has authority to do.
So as the court is making this decision, first of all, which justices are involved in this controlling decision? Is that even a difficult question to ask?
This is a little bit of a math problem. You might need to get your whiteboards out.
Yeah.
So.
Yeah. Okay. Shall I read it? I'll read maybe the abridged version.
Abridged and as fast as you possibly can.
Okay. Justice Roberts. He is writing the majority for parts Roman numeral 1, 2, A1, and 2B. And then we have Sotomayor, Kagan, Gorsuch, Barrett, Jackson, and you will be quizzed, and listeners will be quizzed. They are joining, and they have an opinion with respect to, they're joining one another with respect to parts 2A2 and Roman numeral 3, in which Gorsuch and Barrett joined. Gorsuch and Barrett, the very same two Gorsuch and Barretts that I just said, filed concurring opinions as well. Kagan filed an opinion concurring in part and concurring in the judgment, in which Sotomayor and Jackson joined. Jackson filed an opinion concurring in part and concurring in the judgment. Thomas filed a dissenting opinion, but wait, there's more. Thomas also filed, along with Kavanaugh and Alito, a separate dissenting opinion. Two dissents.
So for those of you who are just listening to and not watching this podcast, Mr. Seltzer is counting
7.
on his fingers how many justices wrote. The answer is 7. There's 7 justices. Oh my goodness.
Opinions.
Okay, so of these 7 opinions, one is the lead opinion, and it's agreed to by Justices Roberts, Gorsuch, and Barrett. Is that correct?
That's right.
Okay, so they don't go to the emergencies question and say, oh, this is, obviously an emergency, or obviously not. Where do they go?
They go to the text of the statute itself. And as we mentioned earlier, the text of the statute doesn't mention tariffs at all. It doesn't mention taxes at all, which, of course, tariffs are. It does mention regulation. And so the question was whether or not you can read that term broadly enough to include this sort of broad tariff authority. And what the court does, or at least the 3 members of the court, is they apply something called the major questions doctrine. And the major questions doctrine is something that's applied in several recent cases, overturning previous executive actions from the Biden administration and going back to the Obama administration, that says when Congress delegates authority to the executive branch, to the president, to make rules, it has to speak clearly. And if you're going to do something really important and really big and really legislative, then the legislature has to be the one to do it. Or if it's going to delegate that authority, we expect it to speak clearly. It can't hide elephants in mouse holes, is the famous line.
And this is especially true in the context where there is the power at issue is expressly granted to Congress.
That's right.
By the text of the Constitution, which is not always true in every major questions case, but
right.
It is here.
That's true. It's worth unpacking, back to Schoolhouse Rock, that the legislature writes the laws and the president enforces them. And under the Constitution, it specifically enumerates certain things that the Congress is in charge of. Mm-hmm. And one of the things specifically enumerated is the tariff power. Mm-hmm. It's nowhere in the president's powers. So if they're going to give it away, what the court says is they have to do so explicitly. And that was true when Biden wanted to do student loan forgiveness. That was true when the Biden administration wanted to have a vaccine mandate.
Through OSHA.
Through these old statutes. They say, we're not going to go back and look at old statutes and
find new meaning.
Find new meanings and new powers.
Yeah.
So why is that important? Like, you have 3 justices that say that the major questions doctrine does not even apply. Why the disagreement?
Well, I think it might make more sense to get to what the majority held first, but I think the reason you had the dissent, which was, of course, Justice Thomas and Alito and Justice Kavanaugh, is they said, well, that only applies to certain categories of legislative power. And they put it into a couple of buckets. One, they said when you're dealing with foreign policy issues or things that may have foreign policy effects, then that, we're not even going to apply the major questions doctrine. We're just going to give deference to the president. And then they said also, Justice Thomas, writing, I think, for himself, said, well, the non-delegation doctrine, and therefore the major questions doctrine, only applies to things that restrict life, liberty, or property, and tariffs aren't that. And so he wouldn't even apply it to the taxing power or any number of other powers that are vested in Article 1, Section 8, if that answers the question.
So Roberts, though, is writing under the major questions doctrine,
right,
applying that.
Yes.
So to circle back to the majority, I know we all want to talk about the concurrences, we all want to talk about the dissents, but to circle back to the majority opinion, it's not real long, but what is kind of the nub of the opinion itself? Where do we land on the major questions doctrine here?
I think where he lands is basically the same place the court has landed over and over again over the last 8 years, which is, when, Congress wants to delegate something that typically falls within its purview to the president, it needs to do so explicitly. And there's a good reason for that. Because again, our government is designed where Congress makes legislative choices. And for most of American history, it couldn't delegate that authority at all. But since we're going to delegate it, since we're going to allow those sorts of delegations, what the court has said is, well, we're going to at least require that you do so explicitly. And that's all that the majority did here. It's a very narrow opinion.
Yeah. So importantly, there were other ways that this decision could have come about. Major questions is a way of interpreting statutes. It's not an interpretation. It's not a doctrine of constitutional interpretation, which the non-delegation doctrine is. So
I think that's actually something that's really important to hesitate on a little bit, because we talk about originalism and we talk about textualism, and originalism is how we interpret the Constitution and textualism is how we interpret statutes. But as we are using these interpretive models, sometimes we have what we think of as an interpretive tool for interpreting the Constitution, when really what we're using is the Constitution as an interpretive tool to interpret a statute, if that makes sense.
Sure, yeah.
So, okay, I interrupted you. Go ahead, Clayton.
No.
If you remember what you were talking about.
No, yeah, I was just going to say, they could have written an opinion that said this is a non-delegable power. No executive, like even if Congress wanted to delegate to the president the power to set tariffs, it is constitutionally prohibited from doing so. That would have been the non-delegation doctrine. But what they did is with that sort of casting a shadow in the background, they employed a tool of statutory interpretation that basically narrows the statute and says if you're going to do that kind of thing, we're not going to say you can't. Sometimes you can delegate that sort of thing, but you just have to speak clearly. So it's a little more cautious and narrow way of deciding this case.
It's sort of we don't assume that you gave a huge swath of power to the president unless you're telling us that you've given us a huge swath of power to the president.
The famous line is, we don't hide elephants in mouse holes.
Precisely.
Yeah.
Precisely.
And then if we actually determine that there is an elephant, that the Congress actually said that, then we can determine if they were actually allowed to delegate.
Yes.
Yeah. So we don't even reach that question.
Right.
Yeah.
Right.
So just kind of as a hypothetical, if Congress had wanted to, under IEEPA, say president can do all tariffs at all times, go forth and prosper, would that have been a violation of the non-delegation doctrine?
That's funny because that came up in oral argument.
That did
You're
come up
asking
in
good question.
Yeah, that's a good question. No, I mean, I think that there you would have a serious non-delegation problem, because you would be delegating the entirety of an Article 1, Section 8 power with no limits on it to the president. And it's interesting because when you go back and you listen to the oral argument in this case, if there was a time where the Solicitor General lost the argument, it was during this back and forth he had with Justice Gorsuch, where Justice Gorsuch asks him, okay, well, is there any limit to your theory? What if Congress decided, well, we don't want to deal with declaring war anymore, so we're going to delegate our entire war-making power to the president? Or what if we don't want to deal with taxing at all anymore? We just want to delegate all of it to the president.
Just take this crown while you're at it.
Yeah, exactly. And the Solicitor General conceded that was within the scope of his argument. And that's just an untenable position at that moment. If that's your view of what can be delegated, then there's really no limit.
And you were saying you could hear the tenor change. Do you think this is where the government lost in oral argument? Because Gorsuch was pressing that point.
Yeah.
It's hard to hear a facial expression, but Gorsuch's facial
his facial expressions are louder than others.
And you could hear other justices come back to that. They came back to it again and again through their questioning. Like, let's go back to what your answer to Justice Gorsuch.
Yeah, right.
And I think that changes the whole tenor because it puts it in a different box.
Yeah.
But that's not ultimately what the court decided here. What the court decided here was, nope, actually that's not a complete and total grant of tariff power. You've just established for us that the tariff is not within this statute, and therefore you don't have it. So why is this not just a pure question of statutory interpretation? Why does the court go to this interpretive tool of the major questions doctrine?
Well, I think there's two.
It is.
Yeah, well, I think it is a question of statutory interpretation, but I think there's two things first. First, they did a lot of work on the actual text. I mean, not to avoid your question, but first they do a lot of work on the actual text where they say, okay, we're looking at this text. It doesn't include the word tariff. It includes regulate. And they said, okay, well, how does that not also include tariffs? And they said, well, the statute's been on the books and the predecessor statutes have been on the books for years. Like historically, the president has never used this for tariff authority except for one argument that was raised in a lower court by Richard Nixon in the 1970s. But other than that, it's never been used.
Under a different statute.
Yes, under the predecessor.
So they haven't used these terms. These statutory terms have never been used like this before.
To the contrary, when Congress wants to delegate taxing and tariff authority, it actually uses words that sound like duties and imposts and ex posts and tariffs and taxes.
Right.
And so what Justice Roberts argues is just looking at the plain text, this is not what we would understand to delegate tariff authority. And so, but to the extent there's any ambiguity under the major questions doctrine, we should be putting the thumb on the scale of not delegating, because we don't delegate broad authority unless we do so explicitly.
And we know Congress can do so if it wants to. There are other statutes delegating the taxing power that don't use these words.
And that's exactly where we get kind of the split between the liberals and the conservatives that are in this plurality, right?
Yeah.
It's the, do we even need to turn to the major questions doctrine, or can we just stick to our standard?
Yeah.
We've looked at the text. We've done a lot of work on the text. We've settled this issue. Do we even need to go to the major questions doctrine?
Yeah.
I'm curious if y'all think that is necessary. Is it necessary to turn to major questions here?
Well, the third of the court would say yes, and a third of the court would say no, and those portions of the court agree that the statute's not constitutional. So you have Justices Kagan, Sotomayor, and Jackson say you do not need the major questions doctrine, and in fact they call it the so-called major questions doctrine because we don't know if it's real. So and they say that just looking at the legislative intent and looking at the statutory text is sufficient to determine the case. Now, I think in this case, you could count to 5 justices who are saying without legislative intent, just looking at the text, that you have 5 justices who would say that the statute does not authorize the president to put tariffs in place. You have 6th Justice, Justice Jackson, who says that we need to look at legislative intent, but you have the other 5 justices just looking at the text, we can get there.
And I think we'll come back to Justice Jackson in a minute, but before we get to her, are we ready to talk about concurrences? Have we talked out the majority?
I would make
opinion enough?
another point. One more point about what you were saying.
Yeah.
Is that it seems like I suppose these were, never mind. That's in the concurrence. So we'll get there.
All right.
Yeah.
All right, we're ready.
Yeah.
Okay, so let's start with Justice Gorsuch. Where does Justice Gorsuch shake out in all of this?
So Justice Gorsuch is one of the few justices on the court that still believes in a full-throated view of the non-delegation doctrine. He doesn't reach it here, but you can feel it lurking in the background of his discussion because he's making a very strong defense of the major questions doctrine. And anyone who's read his opinions over the years knows that he is a real originalist nerd about citing old statutes and treatises and court cases. And so he goes in full originalist on a defense of the major questions doctrine. He's citing old treatises from the 1700s. He's citing courts from England dealing with corporations.
Peak Gorsuch core.
Gorsuch is Gorsuching out really hard. And what he's saying is this idea that you don't assume that you interpret delegations narrowly predates the United States. It goes back to the common law when you're reading contracts. And if you delegate authority, you interpret that delegation narrowly. And he vests the major questions doctrine, this no elephants and mouse holes theory, in the common law that predates the United States. And then he runs it all the way through the 20th century with cases involving,
So in his view, it's the major questions doctrine is just a more specific subset of a broader interpretive method.
This is the way we've always interpreted delegations to agents, even before there was an executive branch.
And that's really important. That's a really important distinction that you made, because the concurring opinions from the liberal justices basically say that major questions doctrine is recent, it's invented, and it's not originalist. They said you're not doing originalism if you employ the major questions doctrine. But it is, because non-delegation is in the text of the Constitution, and this is just a logical outflowing from the
structure of the
non-delegation.
Constitution. Yeah,
it's in the structure.
Yeah, absolutely, absolutely. Yeah. I'm curious what y'all's thoughts are. Justice Gorsuch goes not first to this sort of constitutional structure when he's talking about this really, really old case law. He actually goes first to corporate law and then to agency law. First of all, do you think that that's a reasonable sort of analogy between a corporation and the president, or between an agency and the president? Clayton, you look like you have an answer.
Do. I think it's really reasonable and great.
I'd love to hear your thoughts.
Because I think it really gets at the the core of why we believe originalism is the right way to go, is because basically if you believe in the consent of the governed, what you are.
We do believe in the
Sorry.
consent.
I think where you're going with this is that if you believe in the consent of the governed, basically our Constitution is a big contract, right?
Contract interpretation and agency law
Yes.
are these first principles of a classically liberal order that inform us about the legitimacy of government, and so that analogy works.
So basically, if you go back kind of to that Lockean mentality of this is a social contract, so all of those same things that we've been using for the last 1,000 years to understand how contracts work, we're just going to impute that on what we're doing here.
Right.
And you see that with Gorsuch and a lot of his other recent opinions, like in Rahimi and some of these Second Amendment cases when there was, discussions of text, history, and tradition. One of the arguments that he's made is we do this all the time in contract law and no one thinks it's weird. All of these principles, these canons of construction of how we look at a text, we've done that for centuries in contract law and no one thinks that falls outside of the judicial power. And so why would we treat constitutions or statutes or any of these other things any differently? These sorts of principles would have been understood at the time of the founding by the people who wrote our Constitution, and they're incorporated in the judicial power in the way that we should be looking at statutory and constitutional text.
And it's really important, too, because when we're looking back to 1400 and that time, America wasn't here. We weren't looking at our own Constitution. So if we're looking that far back for our principles of law and our first principles, we don't have a Constitution to look at. So that's kind of where we started. So that's the thrust of Gorsuch's opinion. He spends a lot of time getting angry at the other justices. That's not really a kind way to say that. They have strong disagreements on what the major questions doctrine actually means.
I mean, he torches a straw man, I would say.
Does he? He spends a lot of time talking about how fair he's being to them.
Can we talk about that?
Yes, please.
So just like I really want to hear Chance's take on Justice Gorsuch, like absolutely putting on blast two people, like another person who's actually applying the major questions doctrine.
Yeah.
So even among the major questions doctrine, we have three different views of it in this case. So talk to me about torching straw men.
So it's interesting. So there's been a disagreement between Justice Gorsuch and Justice Barrett on how the major questions doctrine works. And it's a little bit nerdy, but it's whether it's a...
You're so afraid of being nerdy. It's like, what are we doing here?
I'm leaning into it, guys. Like I'm totally leaning in. So the idea is that whether it's what they call an interpretive canon or a substantive canon, okay? And a substantive canon is something outside of the text itself. It's something that like places a thumb on the scale of the way that you should look at a text.
For those who didn't go to law school, a canon is just a rule for interpreting something.
Yeah, it's a fancy word for rule.
It's a fancy word for rule.
And
it's
so,
not like a boom
specifically
goes the
for
canon
the interpretation context.
Yes.
Yes.
Yeah.
And so what, say, for example, Justice Barrett has argued in the past is really you're not applying a substantive canon. It's not a thumb on the scale. It's just common sense. It's the way we use language. So the major questions doctrine is the same way that if I told, for example, my babysitter, make sure that my daughter has fun while I'm gone, that wouldn't include taking them to a theme park because just people don't understand that. So the elephants and mouse holes is really just a common sense application of the way language ordinarily works.
So if I told Congress, you're allowed to go, or I'm sorry, if Congress told the president, you're allowed to go, take my kids to the movies, and instead the president takes them to the movies in Africa, now we have a major questions doctrine problem?
Yes, it's just, you're basically just using common sense to look at a text. It's not a substantive canon where you carry some value judgment to the text itself. For Justice Gorsuch, though, his argument is that basically the non-delegation doctrine is lurking in the background. And therefore we assume that Congress doesn't willy-nilly delegate unlimited power to the president, and therefore we expect them to speak clearly. And so there's a thumb on the scale of saying, we expect a clear statement of a delegation of authority.
This is the same principle that's applied in other contexts.
Right.
If a statute could be interpreted to violate the Constitution or be interpreted to be in line with the Constitution, then the court will try to interpret it in a way that aligns with the Constitution to avoid contravening the Constitution.
Yeah, it's another canon.
It's constitutional avoidance.
Statutory, of constitutional avoidance.
So how does it end up mattering though? Like, it seems like this might be a distinction without a difference, especially because, in this opinion, Gorsuch and Barrett end up agreeing with Justice Roberts. So, like, they get to the same place. Why does it matter?
It's a good question. Oftentimes, it's a distinction without a difference. And, it's interesting because Justice Gorsuch walks through why he thinks that Justice Barrett is just doing non-delegation by another name and where her examples break down. Like, he spends a lot of time talking about that it's not based in the text. When you're doing this common sense approach, Justice Gorsuch argues, you actually are bringing substance because it's outside the text that you told a babysitter whether or not to take your kids to have fun. Because if you had told the other parent, maybe it would be okay for them to go to the movies or go to a theme park. But because it's a babysitter, because it's someone who themselves doesn't have parental authority, that's where that substantive limitation kicks in, not just the text itself, even though the word doesn't change. So he accuses her of doing the same thing that he's doing and then just calling it something else. And by the same token, the reason that you look at the presidential grant narrowly is because the president doesn't have legislative authority. And that's something to remember here that comes up in the majority opinion a lot. The administration here conceded that it doesn't have peacetime tariff powers.
Right.
The administration said over and over again at oral argument, of course the president doesn't have inherent authority to set tariffs. It has to be delegated from the legislature.
In an emergency.
And I think there's an interesting question there that we don't probably have time to get into about whether or not that there is some tariff power that's inherent in the executive power. But setting aside that issue, let's use kind of the remainder of our time to talk about the dissents and also graft into that what Justice Gorsuch has to say about the dissents, because he has a lot to say about the dissents. So starting with I think it makes probably the most sense to start with Kavanaugh's dissent and where he shakes out in all of this and brings with him Alito and Thomas, Justices Alito and Thomas. Where does he fall in all of this?
So do y'all want to take that? I mean, there's a couple of buckets of argument that they raise, and I think you guys can chime in whenever you want. But the first thing he says is, well, of course, the text itself is a broad grant of authority. Like, that's the first thing that he says. And he makes this argument that IEEPA grants this tariff authority because there was a predecessor statute where, President Nixon had once argued that he had authority to do limited tariffs under this predecessor statute.
And I want to pause just here to tell you that particular case that he's talking about, that's not a Supreme Court case, right?
Right, that's right. It was a lower court case. In fact, Nixon had not actually made that argument to begin with. That was a litigation position after the rulemaking where he had brought up this language that I also have it under this statutory authority. And he really, and Kavanaugh really vests his statutory argument there. He says, when IEEPA was adopted, there was this previous argument that Nixon had made, and therefore Congress would have incorporated that broad meaning into IEEPA whenever it was adopted as well. So he starts with the text there. And then there's a second bucket where he says, to the extent it's ambiguous, the major questions doctrine doesn't apply with the same force because this involves foreign policy. This involves really important things.
Okay, so let's hunker down on that for a second. So we've talked about the basis for the major questions doctrine and sort of the foundational reason being that non-delegation core, right? If the dissenting justices are correct, where's our break from the major questions doctrine? Why do we draw the line at foreign powers?
The argument that they make is that the president has some inherent foreign policy authority, right? That's different from congressional authority. And because of that, the courts are going to be more lenient when looking at statutory grants of authority where the president may have some residual foreign policy powers as well.
Isn't that sort of intention, though, here where the claimed power, which is tariffs rather than, for example, sanctions, is at issue because, Congress was expressly given the power to tariff?
Yeah, and that's what the majority opinion and the concurrences point out is that, well, the founders were certainly aware of the need for foreign policy and the impact of foreign policy the tariffs might have. but yet they explicitly enumerated that power to Congress. And that's sort of what the majority opinion lands. But the dissent argues that to the extent the major question doctrine applies at all, it should at least apply with less force in those areas.
Right. Okay.
So after we get through all of that, we also have.
Oh, there's a third.
Oh, I'm so sorry.
There's more.
Let me hear it.
They also argued that here, because there's such important ramifications, and this is their most consequentialist, I think, non-originalist argument, is because it's so important, because it has such major economic downstream effects, and because it would be such a mess for courts to try and untangle what's presidential authority and what's not, that also counsels against the application, or at least the full-throated application of the major questions doctrine. Now, what's interesting there is Justice Roberts responds to that in his opinion, where he says there is no major question exception to the major questions doctrine, which I thought was a really good turn of phrase. But that's sort of their arguments, at least in the Kavanaugh, the Kavanaugh dissent.
That makes sense.
So turning away from the Kavanaugh dissent to the Thomas dissent. And I think we could probably spend an entire 40-minute podcast talking about the Thomas dissent, but we don't have that much time. So 1,000-foot view, what is Justice Thomas arguing? And importantly, is it consistent with what he's argued in the past?
That for one thing I want to point out, though, since this is an originalist podcast full of originalists, is that both, like, his dissent is a really good example of originalism, as is Gorsuch's concurrence, leading to two different conclusions, and it just goes to show that the merits of the method are separate from the conclusion.
I think it's important to emphasize that just because you're doing originalism doesn't mean you're driving toward a specific goal and just calling it originalism. Originalism is a process, right? And so Justice Roberts and Justice Thomas, both applying originalism and both applying the major questions doctrine differently, reach different conclusions.
Yeah. Right. So, it gets accused of cherry picking a lot, but this is good evidence that that's not what it is.
Exactly.
Yeah. But yeah.
Okay. So what does Justice Thomas actually say?
So you had some good takes on the where he goes.
He seems to limit the major questions doctrine to only applying in the context really of the Fifth Amendment. He mentions that it's mentioned in the vesting clause, which is the first clause that delegates power to Congress. And then he immediately talks about the Fifth Amendment in the same context. And he says that the major questions doctrine really only applies in the context, or the non-delegation doctrine only applies in the context of life, liberty, and property. When you're talking about foreign powers or something like that, that's well outside. What we're thinking about is life, liberty, and property for citizens or residents of the country. And so the major questions doctrine would not apply here, right?
Yeah.
Yeah, and it's an interesting take from Justice Thomas, who is in a lot of ways like the OG originalist, if you think about it.
Yeah.
Right.
Because, in the past, he had argued that the non-delegation doctrine and the major questions doctrine, which is sort of its offspring, or at least its cousin, come from the fact that the legislative power is vested in Congress, and therefore Congress can't delegate the legislative power. And what's interesting from a textual perspective is ordinarily that's understood to be all of Article 1, Section 8, because Article 1, Section 8 lays out what the legislative power is. And included in Article 1, Section 8 is a lot of stuff that's not just life, liberty, and property, but includes things like tariffs and duties and impost and ex post. And, and when you look back at, sort of Gorsuch's response to this, he said, well, if that were true, there's a whole bunch of things that are part of ordinarily understood as a legislative power that not just the non-delegation doctrine wouldn't apply to, but the major questions doctrine wouldn't apply to. And he argues at least that Justice Thomas doesn't do the work of explaining where that distinction comes from.
Because I think if the vesting clause, if you just look at it, it's the very first thing. We're going to talk about the legislature, Article 1, Section 1, vesting clause, talking about that the legislative power is invested in Congress. And so then it goes on to list all the powers of Congress. So yeah, it doesn't make sense to me that some of those powers are vested and some of those are not vested. And I'm not sure that we get to really full understanding of which powers are vested or why the Fifth Amendment specifically is associated with the vesting clause.
Now, it really goes back, interesting, a lot of that could go back to sort of Justice Thomas has said before, liberty according to the founders was liberty according to Locke.
That's right.
And so a lot of the ideas about the non-delegation doctrine, when Thomas has written in the past, come from Locke's idea that the legislative power, that what liberty is to be governed in your life, liberty, and restrictions on your life, liberty, and property with legislation as opposed to executive edicts. Mm-hmm. And so there is a sort of philosophical background to this approach, vesting it in the Due Process Clause. It's just an approach that Justice Thomas has never wanted to take before.
So we're not a policy podcast. We're not here to talk about policy. We're here to talk about law and why the law is the way that it is and what is happening in these Supreme Court cases. But without getting into the policy question here, what happens now? What are the hurdles that are coming down the pike for both the government and for the petitioners in this case?
Well, I'll say that if you're asking like what is going to happen in this case specifically,
procedurally, what's going to happen?
So it's going to go back to the Court of International Trade. The Supreme Court, there was a dispute about whether that was the appropriate venue, and the court said it is. And then they're going to decide if we're going to do refunds or if we're going to do just prospective relief, meaning that they're just going to declare that the tariffs violate the statute and that they can't be enforced going forward. We don't know what they're going to do yet, and so right now there's actually nothing going to happen at all.
So really, this was not a particularly effectuous sort of holding from the court. We don't really know what the ultimate outcome here is going to be.
It declared the meaning of the statute, and that's about it.
Yeah.
I don't think it's sound and fury signifying nothing. There's certainly guidance for the lower court.
Certainly. Yeah.
I mean, certainly the tariffs will not go forward under IEEPA in the future. Right. But it's important to remember, the Supreme Court decides questions, not cases.
Mm-hmm.
Right.
This is often forgotten. The Supreme Court, at the end of the day, its job is to decide a discrete legal question and then send things back down to the lower courts.
That is normal.
And our discrete legal question here is, can the president under IEEPA issue unilateral tariffs? And the answer to that question is no.
No.
And that's all we know at this point.
Yep.
Well, thank you all so much for joining us. Thank you for being here with me today to talk about this case. I look forward to more discussions like this in the future, and I really hope that we're able to get into more originalism